Sir, what's going
We
on?
got a report about someone growing illegal plants out here. You match who we're looking for.
Match? You gotta be kidding me.
Yeah, black male, middle age. That's what we got.
That's not a description. That's just you profiling.
Sir, don't make this harder or you'll be detained.
I'm a federal judge and I know the law more than you.
The body cam jumps to life in a burst of harsh midday glare. No intro, no warning, just confrontation on impact. A black man in gardening gloves rises slowly from his flower bed, framed close and upward by the officer's body cam. His expression puzzled, then tightening. But the rookie officer steps forward like he's cornering a suspect, not addressing a homeowner. You can feel the moment he decides this man doesn't belong on the very lawn he's tending. Quick flashes, orchids swaying behind him, the officer's clipped tone, tension spreading through the quiet yard. Then the man lifts something the rookie never expected to see. A judicial ID, gold-sealed, impossible to misread. But instead of backing off, the rookie escalates, challenging his right to be here, his identity, his authority. The camera captures the exact instant confusion turns to anger and patience turns into consequences that will cost the city $15 million. Before we continue, where are you watching from? If this is your first time here, hit that subscribe button. Stories like these need to be heard. Your support brings more truth to light. But how did a rookie officer get so reckless that he tried to detain the chief presiding judge on his own property?
Charleston, South Carolina. Magnolia Heights, an established residential neighborhood where tree-lined streets and historic homes create postcards of Southern elegance. Property values averaging $650,000. Demographics predominantly white. The kind of neighborhood where everyone supposedly knows everyone, except when they don't want to. It was 3:47 p.m. on a Saturday in June. Temperature 89 degrees, humidity thick enough to taste. The kind of afternoon where lawns demand attention and weekend projects can't wait for cooler weather. Judge Arthur Pemberton was in his front yard tending to his orchid collection. He was 56 years old, chief presiding judge for South Carolina's 9th Judicial Circuit, a position he'd held for 8 years after 23 years on the bench. His jurisdiction covered 6 counties. His rulings shaped legal precedent. His courtroom commanded respect from prosecutors and defense attorneys alike. But that Saturday afternoon, he wasn't Judge Vance. He was just Arthur, wearing cargo shorts, a faded college t-shirt, and gardening gloves, carefully transplanting rare orchids into ceramic pots, arranged along his front walkway. He'd been cultivating orchids for 15 years. Phalaenopsis, Cattleya, Dendrobium, species requiring specific care and considerable knowledge. His collection had been featured in Southern Living magazine 2 years earlier. Several specimens were valued at over $2,000 each. This wasn't casual gardening. This was serious horticulture. Officer Dylan Carpenter had been with the Charleston Police Department for 11 months. At 24 years old, he was fresh from academy, assigned to residential patrol, eager to make arrests that would build his record. His training evaluations had noted concerns. Demonstrates tendency toward aggressive engagement. Should develop better assessment skills before independent assignments. But staffing shortages meant rookies were patrolling solo within weeks. That afternoon, Cole received a dispatch call. Neighbor complaint from 2851 Magnolia Drive. Suspicious black male in yard at 2847 Magnolia. Doing something with plants that look strange. Possibly drugs. The caller was Patricia Donovan, a 64-year-old white woman who lived on Magnolia Drive for 30 years. She'd watched Arthur move in 2 years ago and had never once introduced herself, never welcomed him to the neighborhood, never acknowledged his presence beyond suspicious stares when he checked his mail. Carpenter responded within 4 minutes. His body cam activated as he exited his patrol car and immediately focused on Arthur in the front yard. The footage shows Carpenter's approach, fast, aggressive, no observational pause to assess the situation. He saw a black man with plants and made immediate assumptions. The body cam jerked into frame tight and invasive. Arthur looked up from his orchids, his expression shifting from mild curiosity to controlled concern. "Sir, step away from the plants. I need to see your hands." Arthur stood slowly, removing his gardening gloves with deliberate care. His voice was measured, calm, carrying the authority of someone accustomed to controlling rooms. "Officer, can I help you with something?"
The Bodycam captured Carpenter's response. Sharp, accusatory, no professional courtesy. "We got a call about suspicious activity. Those plans, what are they?" Arthur glanced at his orchids, then back at Carpenter with an expression suggesting he couldn't quite believe the question. "They're orchids. Phalaenopsis and Cattleya hybrids. I'm transplanting them into larger containers." Carpenter stepped closer, his boots crossing from public sidewalk onto Arthur's property without invitation or legal justification. "They look like marijuana plants. I need to inspect them." Arthur's jaw tightened. The Bodycam shows his body language shift, still calm but coiled beneath. "Officer, these are legal ornamental orchids. You're currently on my private property without invitation or probable cause. I'm going to ask you to step back to the sidewalk." Carpenter's hand moved to his belt, hovering near his handcuffs. "Sir, I'm conducting an investigation. You need to cooperate." "Investigation of what?" Arthur's voice carried steel beneath velvet. "Growing flowers in my own yard?" The Bodycam captured Carpenter's face, ego wounded, authority challenged, doubling down rather than reassessing. "Don't get an attitude. I can detain you for obstruction if you interfere with my investigation." Arthur pulled his phone from his pocket, moving slowly and deliberately. "Officer, I'm recording this encounter. You've entered my property without warrant or exigent circumstances. You've accused me of criminal activity based on ornamental plants, and you're now threatening detention for exercising my constitutional rights. I suggest you verify your probable cause before this escalates further." Carpenter's voice rose. "Put the phone down! Stop recording!" "I have every legal right to record police activity on my own property." Arthur Stone remained infuriatingly calm, the voice of someone who'd spent decades in courtrooms watching officers testify. "What's your name and badge number?" The question seemed to finally penetrate Carpenter's aggressive certainty. For the first time, doubt flickered across his face. But instead of retreating, he'd pushed forward, ego overriding judgment. "I'm Officer Carpenter, badge 4821, and you need to identify yourself right now." Arthur reached into his pocket and pulled out his driver's license and another card, judicial identification with the South Carolina state seal. He held both at eye level, 2 feet from Carpenter's Bodycam. "I am Chief Presiding Judge Arthur Pemberton, 9th Judicial Circuit. This is my residence. Those are my orchids. You are currently trespassing on the property of a state judicial officer without legal justification. I'm ordering you to leave immediately." The Bodycam captured Carpenter's face perfectly. His eyes widened, his mouth opened slightly. For 3 full seconds, he stood frozen, processing the catastrophic error he just made. But ego, wounded, defensive, desperate, wouldn't let him retreat. His voice came out strained, defensive. I just investigating a complaint. I have to check." "You have no probable cause." Arthur's voice carried courtroom authority now, no longer the patient homeowner, but the judge who commanded respect from everyone in his jurisdiction. "You have violated my Fourth Amendment rights. You've trespassed on judicial property. You've made baseless accusations about legal plants. And you're not threatening detention for exercising my constitutional rights. I suggest you verify your probable cause before this escalates further." Have you ever seen someone stay calm under pressure like this? Tell me in the comments.
What happened next was a textbook case of an officer's ego transforming a bad decision into career-ending misconduct. Carpenter could have apologized, retreated, and escaped with only embarrassment. Instead, he escalated. "I still need to verify these plants aren't illegal." Arthur's patience was eroding. "Officer Carpenter, I've identified myself as Chief Presiding Judge.
My credentials are valid. My property is private. You have no warrant, no exigent circumstances, and no legal authority to conduct any search. Leave. Now." But Carpenter couldn't accept defeat. He'd been challenged, contradicted, and proven wrong, all on Bodycam. Retreating meant admitting error. So instead, he attempted to assert control through the only means he understood: detention. "Sir, you're being uncooperative. I'm going to need you to step back while I complete my investigation." He took a step toward Arthur's orchids. Arthur moved to block his path, not aggressively, just positioning his body between Carpenter and his property. "Don't touch my plants. Don't move further onto my property. You are trespassing." Carpenter's hand shot out and grabbed Arthur's arm. The Bodycam captured the moment clearly: Arthur standing still, Carpenter initiating physical contact, aggressive grip on a state judicial officer's forearm. Arthur's voice dropped to absolute zero. "Remove your hand immediately. You are now committing assault on a judicial officer." "You're obstructing my investigation. I'm placing you in detention." The Bodycam shows Arthur's face. Not fear, not panic, but cold calculation. He didn't pull away violently, didn't escalate physically, just spoke with devastating clarity. "Officer Carpenter, you are creating evidence for multiple criminal charges and civil rights violations. Every second you maintain physical contact compounds your liability. Your Bodycam is recording your assault on a chief presiding judge. I'm advising you for the final time. Release me and leave my property." Carpenter's radio crackled. His dispatcher's voice cut through. 4821, be advised backup is en route to your location per supervisor request. Confirm situation status. Carpenter's face showed the first real crack in his certainty. "Backup? I didn't request." A second patrol car pulled up within 30 seconds. Sergeant Vincent Bradley stepped out, a 19-year veteran who'd been monitoring the radio traffic and recognized the address. He took one look at the scene. Carpenter gripping Arthur's arm, Arthur standing rigid with obvious authority, orchids scattered around them, and his face went pale. "Carpenter, release him immediately." "Sarge, this subject was uncooperative, wouldn't let me inspect." Bradley cut him off, his voice tight with barely controlled panic. "That's Judge Pemberton, Chief Presiding Judge. You're assaulting a state judicial officer. Release him now." Carpenter's hand dropped from Arthur's arm like he'd been burned. His face cycled through confusion, fear, and dawning horror. Bradley approached Arthur with professional deference.
"Judge Pemberton, I apologize for this encounter. Officer Carpenter was responding to a complaint and clearly failed to properly assess the situation. You're obviously free to go. This detention is terminated." Arthur rubbed his arm where Carpenter had grabbed him, his voice carrying judicial precision. "Sergeant Bradley, Officer Carpenter entered my property without invitation, accused me of criminal activity based on legal orchids, ignored my identification as a judicial officer, refused lawful orders to leave private property, physically detained me without cause, and committed assault when I attempted to protect my property from illegal search. I will be filing formal complaints through appropriate channels, and I'm documenting this entire encounter for legal proceedings." Bradley nodded slowly, his expression grim. "Understood, sir. We'll preserve all Bodycam footage and file incident reports. Is there anything you need from us at this moment? I need both of you off my property. Immediately." If you were in Judge Vance's shoes, what would you have done? Within 2 hours of Sergeant Bradley leaving Judge Pemberton's property, the incident report reached the desk of Internal Affairs Captain Diane Lawson. She read it once, went pale, read it again, and immediately called the Chief of Police. By Monday morning, Officer Carpenter's personnel file was spread across multiple desks: Internal Affairs, City Attorney's Office, Police Chief's Office, and Risk Management. What they found was a pattern that should have prevented Carpenter from ever receiving badge authority. The 911 call that had triggered Carpenter's response was recording, as all emergency calls are. The audio was chilling in its casual racism. Dispatcher: 911, what's your emergency? Patricia Donovan: there's a suspicious black man in the yard next door doing something with plants that look like drugs. Dispatcher: ma'am, can you describe what makes the activity suspicious? Patricia Donovan: well, he's black and this is a nice neighborhood. He's always doing things in his yard and I don't think he belongs here. Dispatcher: has he threatened anyone or committed any observable crime? Patricia Donovan: he doesn't need to commit a crime for you to check it out. That's what police are for, keeping neighborhoods safe. The dispatcher, following protocol, created a call log describing suspicious activity with possible drug-related plants, but the underlying complaint was pure racial profiling. A black man existing in a nice neighborhood where a white woman didn't think he belonged. Officer Carpenter's training records revealed he'd received failing scores in de-escalation scenarios. Academy instructors had noted, Cadet Carpenter demonstrates poor judgment in ambiguous situations, tends toward aggressive response rather than assessment. Recommend additional training before field assignment. That recommendation was noted and ignored. His field training officer evaluations included warnings. Officer Carpenter needs significant improvement in recognizing when force or detention is appropriate versus when conversation and verification are sufficient. He operates on assumptions rather than evidence. 3 formal complaints had been filed against Carpenter during his 11 months of service. Complaint number 1. Black teenager stopped for suspicious behavior while waiting at a bus stop. Teenager was heading home from school. Carpenter demanded ID, conducted pat-down search, found nothing. Complaint dismissed with notation, officer exercising reasonable caution. Complaint number 2. Hispanic man stopped while jogging through neighborhood. Carpenter claimed man matched description of suspect. No suspect existed. Complaint dismissed with notation, mistaken identity, no malicious intent. Complaint number 3. Black woman walking her dog questioned about what she was doing in the neighborhood. Woman lived 3 houses down from where Carpenter stopped her. Complaint dismissed with notation, officer maintaining community awareness. 3 complaints in 11 months, all involving people of color, all involving baseless suspicion, all dismissed without meaningful discipline or retraining. And now, Carpenter had assaulted a chief presiding judge in his own yard. Judge Pemberton filed formal complaints through 3 separate channels: Charleston Police Internal Affairs, South Carolina Law Enforcement Division, and the State Judicial Standards Commission, which had authority to investigate interference with judicial officers. His written complaint was devastating in its precision. On June 15th at approximately 3:47 p.m., Officer Dylan Carpenter entered my private property without warrant or invitation, accused me of criminal activity based on legal ornamental plants, refused to accept my identification as chief presiding judge, physically detained me without probable cause, and committed assault when I attempted to protect my property from illegal search. This represents not only individual misconduct, but patterned behavior, as evidenced by Officer Carpenter's complaint history. I am filing this complaint both as a private citizen whose rights were violated and as a judicial officer concerned about systemic failures in training and accountability. Internal Affairs launched immediate investigation. Every body cam frame was analyzed. Dispatch recordings were reviewed. Carpenter's complaint history was compiled. And the conclusion was undeniable. Carpenter had committed multiple violations of policy, law, and constitutional rights. Do you think the officer knew who he was messing with? Let me know below. Tuesday morning, Police Chief Gerald Whitfield held an emergency meeting with his command staff, city attorneys, and risk management. The agenda had one item: the Judge Pemberton incident and its catastrophic implications. The city attorney's assessment was blunt.
we have no defense. Officer Carpenter violated clearly established Fourth Amendment rights by entering private property without cause. He detained a judicial officer without justification. He ignored explicit orders to leave, and he committed assault and battery, all captured on Bodycam. If this goes to trial, we're looking at a jury verdict that could exceed $20 million. Judge Pemberton, exercising his authority as chief presiding judge, convened a special investigative panel examining the incident as potential interference with judicial function, a serious matter under South Carolina law. His position gave him direct access to investigative resources and legal mechanisms unavailable to ordinary citizens. The panel's findings, released within 10 days, were damning. Officer Carpenter initiated contact based on racially motivated 911 call containing no articulable criminal activity. Carpenter entered private property without legal justification. Carpenter refused to accept valid judicial identification. Carpenter conducted investigative detention without probable cause. Carpenter committed assault and battery on a state judicial officer. Carpenter's pattern of complaints indicated systemic bias unaddressed by his department. But the investigation revealed something more disturbing. Internal emails between Carpenter and other rookie officers showed a culture of aggressive enforcement encouraged by certain supervisors. One email from Carpenter to a fellow officer read, "Another welfare check on someone who doesn't belong in a rich neighborhood. Easiest overtime ever." The cavalier attitude toward pretextual stops, the casual racism embedded in the phrase "doesn't belong," and the implication that such stops were common enough to be routine, all pointed to problems far beyond one officer. Judge Pemberton gave a deposition that became required viewing in police academies nationwide. His testimony was measured, precise, and devastating. Officer Carpenter didn't see a homeowner tending his garden. He saw a black man in an affluent white neighborhood and assumed criminality. When I identified myself as chief presiding judge, he didn't apologize or retreat. He escalated. Why? Because in his worldview, a black man claiming authority couldn't possibly be telling the truth. That assumption, that implicit bias, is what transformed a bad stop into criminal assault. How do you feel seeing the truth finally come out? Comment your thoughts. The termination hearing for Officer Dylan Carpenter was held 3 weeks after the incident. Unlike typical disciplinary proceedings held internally, Carpenter's assault on a judicial officer meant the hearing was conducted before a special panel including representatives from the State Law Enforcement Division. The evidence presented was overwhelming. Bodycam footage playing on a large screen showing every moment from aggressive approach to physical assault. Dispatch recordings proving the complaint was racial profiling. Carpenter's complaint history demonstrating pattern behavior. Expert testimony from constitutional law scholars explaining the multiple rights violations. Carpenter's attorney attempted to argue that he'd been following protocol for investigating suspicious activity. The argument collapsed immediately. Panel members asked, what was suspicious about ornamental orchids in daylight in a homeowner's front yard? Carpenter's attorney had no answer. The panel's decision was unanimous: termination for cause. Officer Dylan Carpenter was fired from the Charleston Police Department effective immediately. His law enforcement certification was permanently revoked by the state. His name was entered into national decertification databases, preventing employment in any law enforcement capacity anywhere in the United States. The termination letter was specific and damning. Officer Carpenter demonstrated pattern bias, violated constitutional rights, ignored judicial authority, committed assault on a state official, and showed no understanding of appropriate use of police power. He is unfit for law enforcement service. Carpenter was 24 years old. His career lasted 11 months. His pension was forfeit, and he faced potential criminal charges for assault on a judicial officer. But individual accountability was only beginning. Judge Pemberton filed a federal civil rights lawsuit in the District of South Carolina. The complaint named Officer Dylan Carpenter, Sergeant Vincent Bradley for supervisory failure, Police Chief Gerald Whitfield for inadequate training, and the City of Charleston for municipal liability under Monell. The claims included violation of Fourth Amendment rights, unlawful entry and seizure, assault and battery,
intentional infliction of emotional distress, negligent training and supervision, and violation of state law protecting judicial officers from interference. Damages sought $15 million. The city's legal team evaluated the case and reached grim conclusion. They had no defense. The body cam proved everything. The pattern evidence showed systemic failure, and a jury would see a respected judge assaulted in his own yard by a rookie cop who couldn't recognize orchids from marijuana. Settlement negotiations began immediately. The city's initial offer, $3 million plus policy reforms, was rejected. Judge Pemberton's attorneys demanded full accountability, $15 million, comprehensive reforms, public acknowledgement of wrongdoing, and federal monitoring of police training.
Well, where do you think you're going? This area's
I
restricted.
just showed you my clearance. Step aside.
Yeah, anyone can print a badge. You don't even look like it.
I don't have time for this. I'm retrieving evidence for a court order.
Did I stutter? Back up, lady.
Lena Porter, state attorney.
The body cam snaps on to a blinding hallway glare. No setup, no pause, just instant conflict. A black woman in a tailored suit stands firm in the center of the frame, her composure tight as steel. Yet a rookie cop throws his body in front of her like a human barrier, fueled by ego and something far uglier. He crowds the lens, postures, tests her. You can feel the shift the moment he decides she doesn't belong here. Quick flashes, her controlled breath, his puffed-up stance, the air tightening between them. Then she raises something that should have ended the entire interaction. A gold credential that gleams under the fluorescent lights, cutting through the tension like a blade. But instead of stepping aside, the rookie doubles down, challenging her authority, her position, and even her right to stand in the space she's already cleared to enter. The camera catches the exact second disbelief turns into fury, and professionalism turns into a promise of consequences. What happens next didn't just end a rookie's career. It ignited headlines, triggered a $10 million settlement, and left the entire department scrambling to explain why their newest officer thought he had the power to block the state attorney herself. Before we continue, where are you watching from? If this is your first time here, hit that like and subscribe button. Stories like these need to be heard. Your support brings more truth to light. But what made this rookie so bold, and how did his own body cam become the evidence that destroyed him?
Miami-Dade County Justice Building, Florida. 3rd floor, restricted evidence wing. 4:15 p.m. on a Wednesday in November. Fluorescent lights humming overhead. Polished marble floors reflecting institutional authority. The kind of building where prosecutors, judges, and law enforcement navigate overlapping jurisdictions with established protocols and mutual professional respect. Usually, Lena Porter was 41 years old, chief state attorney for Miami-Dade County's Public Corruption Unit. She'd been with the state attorney's office for 14 years, rising from junior prosecutor to heading one of the most politically sensitive divisions in Florida. Her current caseload included a major bribery case involving 2 city council members, a police captain, and a contractor accused of rigging municipal contracts worth $8 million. The case was scheduled for trial in 9 days.
That afternoon, she'd received emergency notification that newly discovered evidence, financial records seized from the contractor's office, had been transferred to the restricted evidence wing for processing. Time was critical. The defense was filing motions to suppress. She needed to review the documents immediately to prepare prosecution strategy. She arrived at the evidence wing entrance at 4:12 p.m., her state attorney credentials clearly visible on a lanyard around her neck, her briefcase containing the court order authorizing evidence access, her phone showing email confirmation from the Evidence Control Unit supervisor approving her entry. Officer Marcus Hayes was with her, a 16-year veteran with the State Attorney's Office Security Division who'd escorted dozens of prosecutors through this exact process hundreds of times. The third-floor security checkpoint was normally staffed by experienced officers familiar with the building's regular personnel. But that afternoon, due to shift coverage gaps, the post was manned by Officer John Reeves, 23 years old, 3 months with Miami-Dade Police, recently assigned to courthouse security as his first solo posting. Reeves had minimal training for the assignment. His academy education covered street patrol, traffic enforcement, and arrest procedures. But courthouse security protocols, evidence handling regulations, and recognition of prosecutorial authority, that received a 2-hour orientation he'd completed 4 days earlier. The body cam footage shows Lena approaching the checkpoint with professional efficiency. She's carrying her briefcase, walking with purpose, her credentials visible. Hayes is beside her, also displaying his security badge. Standard procedure. 2 authorized personnel seeking routine evidence access. Reeves stepped directly into their path, his body language aggressive from the first moment. "Whoa, where do you think you're going? This area is restricted." Lena stopped, her expression showing mild surprise but professional patience. She lifted her credentials, holding them at eye level. "I just showed you my clearance. I'm State Attorney Lena Porter. This is Officer Hayes from our security division. We're here to access evidence under court order." The body cam captured Reeves' face clearly. No recognition, no professional courtesy. Just immediate dismissiveness tinged with something else, the assumption that this black woman in a suit, despite her credentials and explanation, couldn't possibly have legitimate authority. "Anyone can print a badge. You don't even look like it." The statement hung in the air, heavy, coded, unmistakable in its implication. Hayes' voice carried warning. "Officer, I've worked security in this building for 16 years. Ms. Porter is Chief State Attorney for Public Corruption. Verify her credentials through your dispatch if you have concerns, but do not block authorized personnel from performing their duties." Reeves ignored him, his attention fixed on Lena. His voice rose. "I'm retrieving evidence for a court order. You need to step aside immediately." Reeves moved closer, puffing his chest. "Did I stutter? Back up, lady." Hayes stepped between them, his voice dropping to controlled authority. "Officer Reeves, I'm instructing you as senior security personnel to verify and allow access. You're currently in violation of Florida Statute 843.02, obstruction of justice. If you do not comply immediately, I will have you arrested and charged." That threat, delivered by someone who actually had the authority to follow through, should have shocked Reeves into compliance. Instead, it triggered his ego's final desperate defense. "You threatening me?" His voice cracked with indignation. "You're not even supposed to be here." 3 security cameras captured different angles of the hallway. The footage would later show Lena standing calmly, with credentials displayed, Hayes positioned professionally to her left, Reeves blocking their path with increasingly agitated body language, and several staff members who'd emerged from offices to witness the confrontation.
One staff member, a paralegal named Jennifer Martinez, had begun recording on her phone. Her footage captured audio the body cam missed. Hushed conversations among witnesses expressing disbelief at Reeves' behavior. Hayes made one final attempt at de-escalation. "Officer, I'm going to reach for my phone to call your supervisor directly. Do not interpret that movement as a threat." He slowly pulled his phone and dialed.
The call connected to Sergeant Linda Morrison, Reeves' direct supervisor. Hayes explained the situation clearly, concisely, professionally. Morrison's response was immediate. Put Reeves on the phone. Reeves refused to take it. I'm handling the situation. The body cam captured Morrison's voice through Hayes' phone speaker, loud enough to be clearly audible. Officer Reeves, this is a direct order. Verify the credentials and allow passage immediately. State Attorney Porter has full authorization to access that wing. Reeves's face flushed red. His hands were shaking. He'd been publicly contradicted by dispatch, by senior security, and now by his own supervisor. Every authority figure was telling him he was wrong, and instead of accepting correction, his ego demanded validation. His voice rose to near shouting, "This is my checkpoint. I determine who passes." Lena exchanged a glance with Hayes. Her expression showed not fear, but weary recognition. She'd seen this before. The entitled officer, the abuse of power, the racism disguised as protocol. She'd prosecuted cases built on exactly this behavior. She pulled out her phone and began recording. Officer Reeves, badge number 4729, you are currently obstructing a state attorney in performance of official duties, ignoring directives from your chain of command, and creating an incident that will result in formal complaints and potential criminal charges. I am documenting this encounter for, don't record me. His hand shot out toward her phone. Do you think he would have acted the same way if Lena wasn't a black woman in power? What happened in the next 7 seconds was captured from 4 different angles. Reeves' body cam, security camera 3A mounted on the ceiling, security camera 3B at the end of the hallway, and Jennifer Martinez's cell phone video. When played side by side in subsequent legal proceedings, the footage told an undeniable story of assault and battery committed by a law enforcement officer against a state official. Reeves lunged toward Lena's phone, his movements sudden and aggressive. Hayes stepped forward instinctively, putting himself between them. That movement, protective, professional, completely reasonable, triggered Reeves's final catastrophic decision. This is your last warning. Back up.
Lena stood her ground, her state attorney credentials still held high in her left hand, her phone recording in her right. I am the state attorney. Move! Ree's hand shot out and connected with Lena's shoulder. The shove was violent. Not a touch, not a guide, but forceful propulsion designed to move her body backward. The security camera footage shows her stumbling, her briefcase falling, her body tilting off balance. She fell backward, her shoulder and hip impacting the marble floor with sickening force. Her head snapped back but didn't hit. She'd managed to tuck her chin at the last instant, training from years of self-defense classes preventing worse injury. The body cam captured Reeves' immediate response. Not horror at what he'd done, not concern for whether she was injured. Justification. Stop resisting! Stop resisting! But Lena wasn't resisting. She was on the ground, stunned, her credentials scattered beside her, her phone still recording from where it had slid across the floor. Hayes dropped to his knees beside her. Miss Porter, don't move. Are you injured? Multiple voices erupted simultaneously. Jennifer's cell phone video captured staff members shouting, "He just assaulted her! Someone call 911! What the hell is wrong with you?" A security guard who'd been monitoring cameras came running from the command post. He took one look at Lena on the ground, at Reeves standing over her, and his face went pale. Oh my God, that's the state attorney! Reeves' expression shifted, his face registering to delayed recognition and growing horror. He took a step back, his hands rising. She wasn't authorized. She wasn't supposed to. Hayes helped Lena to a sitting position. His voice was tight with controlled fury. You just committed assault and battery on a chief state attorney. Don't say another word. Don't move. Don't touch anything. Lena's voice, though shaken, carried absolute authority. All footage is to be preserved immediately. Building security locked down all recordings from this hallway for the past 30 minutes. Officer Hayes, contact Internal Affairs and file formal complaint for assault, obstruction of justice, and violation of state officials' authority. And someone call my office. I need assistant state attorneys here within 15 minutes. The security guard helped Lena to her feet. She was visibly shaken, but composed,
her years of courtroom experience keeping her focused. Her shoulder throbbed, her hip would bruise significantly, but she was conscious, mobile, and absolutely determined that this encounter would have consequences. Reeves reached for his body cam. The security footage captured him attempting to turn it off, but courthouse body cams had auto-lock features preventing deactivation during incidents. His attempt failed, preserved forever on the recording that would destroy his career.
Within 7 minutes of Lena hitting the floor, the third floor of the Miami-Dade County Justice Building transformed into controlled chaos. Multiple supervisors converged simultaneously. Sergeant Morrison responding to Hayes' call, Internal Affairs investigators responding to automated incident alerts triggered by the assault report, and Building Security Command scrambling to secure all evidence and footage. Reeves stood frozen, his face cycling through emotions: panic, defiance, fear, confusion. He tried to speak as Morrison arrived. "Sergeant, she wasn't authorized. I was following protocol." Morrison cut him off with a raised hand. "Don't say anything. You're under investigation. Step away from everyone and wait for IA." But Reeves couldn't stop defending himself. "I'm telling you, she tried to force entry into restricted." Sergeant Morrison's voice dropped to barely controlled fury. "Officer Reeves, the woman you just assaulted is Chief State Attorney Lena Porter. She oversees prosecution of public corruption cases, including police misconduct. She had full authorization, confirmed by Security Command, by myself, and by Officer Hayes, who has 16 years in this building. You ignored directives from your chain of command. You refused to verify credentials. You escalated a routine authorized access into physical assault. Do you understand the magnitude of what you've done?" The words seemed to finally penetrate. Reeves' face went pale. "I didn't know she was—" Morrison's response was sharp. "You didn't verify. That's the problem." Internal Affairs Lieutenant Marcus Chen arrived with 2 investigators. He took immediate command of the scene, his voice carrying administrative authority. "Officer Reeves, you're suspended, effective immediately, pending investigation. Surrender your service weapon and badge. Everyone who witnessed this incident will provide statements. All footage is being preserved under evidence chain of custody." Lena had moved to a nearby office where building medical staff were evaluating her injuries. Paramedics arrived despite her insistence she didn't need ambulance transport. They documented visible bruising forming on her shoulder, checked for signs of concussion, and recommended hospital evaluation that she declined in favor of being examined by her personal physician. But she insisted on remaining in the building long enough to provide her official statement. She sat in a conference room, her shoulder throbbing, and dictated a formal complaint that would become the foundation of both criminal charges and civil lawsuit.
At approximately 4:15 p.m., I arrived at the third-floor evidence wing checkpoint to access materials under authorized court order. I presented my state attorney credentials clearly to Officer John Reeves. He refused to acknowledge my authority, made racially charged comments suggesting I didn't look like someone who should have access, ignored directives from Security Command and his supervisor to verify credentials, escalated the encounter through aggressive verbal and physical intimidation, and ultimately committed assault and battery by shoving me forcefully, causing me to fall and sustain injury. This assault was unprovoked, unjustified, and represents both criminal misconduct and civil rights violation. Lieutenant Chen asked the critical question, "Ms. Porter, in your professional opinion as state attorney, do you believe racial bias played a role in Officer Reeves' actions?" Lena's response was measured but unequivocal. "Officer Reeves told me I didn't look like someone authorized for access, despite seeing my credentials. He escalated with a black woman showing state authority in ways I have never witnessed officers do with white prosecutors. His assumption that my credentials were false, his refusal to verify despite multiple directives, and his ultimate use of force all indicate a pattern consistent with racial profiling and bias against black authority figures." Within 2 hours, local news had the story. By evening, it was national.
By the next morning, it had exploded across social media with hashtag state attorney assault and racism in uniform trending. The footage, all 4 angles, was obtained through public records request and played on every network. The visual was damning. A professional black woman in business attire, showing credentials, being shoved by a white rookie officer who'd ignored every directive to stand down. District Judge Martha Williams, who was overseeing the corruption case Lena was prosecuting, issued a rare public statement. The assault on Chief State Attorney Porter is an affront to the rule of law and the dignity of this court. Those who administer justice must themselves be subject to justice when they commit violence against officers of the court. The Miami-Dade police chief held a press conference within 24 hours. His statement was defensive and inadequate. "We are investigating the incident thoroughly. Officer Reeves has been suspended pending review. We take allegations of misconduct seriously." That statement lasted less than a day before public pressure forced a stronger response, acknowledging the severity and promising accountability. Do you think the department reacted fast enough, or only because they realized who she was?
The investigation into Officer John Reeves quickly expanded beyond individual misconduct to expose systemic failures in training, supervision, and accountability. Internal Affairs obtained Reeves' complete training records. What they found was damning. His academy performance evaluations included multiple warnings, demonstrates difficulty with de-escalation scenarios, tends toward assumption-based rather than evidence-based decision-making. Recommend additional training before field assignment. Those recommendations were noted and ignored. Staffing shortages meant Reeves was pushed through to active duty with minimal remedial training. His courthouse security orientation, the training that should have prepared him to recognize and properly interact with prosecutors, judges, and other legal personnel, consisted of a 4-hour classroom session. No practical scenarios. No assessment of his ability to verify credentials or handle authority challenges. Just PowerPoint slides about building layout and radio codes. Investigators also uncovered Reeves' history of complaints that predated the assault on Lena. During his 3 months of service, 2 formal complaints had been filed. Complaint number 1, aggressive interaction with a Hispanic attorney attempting to access courthouse records. Attorney alleged Reeves demanded proof you're really a lawyer, despite proper identification. Complaint number 2, confrontational encounter with a black paralegal carrying files. Reeves allegedly questioned whether she'd stolen those documents before verifying her courthouse employee badge. Both complaints had been dismissed with notations like "officer was being cautious" and "no policy violation occurred." No retraining was mandated. No pattern recognition flagged the issue. The investigation expanded to examine broader courthouse security culture. What emerged was troubling. Security officers operated with minimal supervision and vague directives about maintaining access control. There was no clear protocol for verifying credentials when an officer had doubts. There was no escalation procedure requiring supervisor consultation before denying access. And there was no meaningful accountability when officers made errors. Constitutional law professor Jamal Thompson provided expert analysis in subsequent interviews. Officer Reeves didn't act in a vacuum. He acted as a product of a system that provided inadequate training, failed to address pattern complaints, and essentially told rookie officers to rely on their gut instincts rather than proper verification procedures. When those gut instincts are shaped by racial bias, consciously or unconsciously, you get exactly what happened here. A black woman with full authority being treated as a threat. The case became symbolic. If the chief state attorney, someone with institutional power,
legal expertise, and documented authority could be assaulted inside her own building, what happened to ordinary black citizens interacting with officers who made the same biased assumptions? Civil rights organizations seized on the case as evidence of systemic racism within law enforcement. Protests were organized outside the Justice Building. Advocacy groups demanded comprehensive reforms. And Lena herself, once she'd recovered from her injuries, became vocal about the need for change. In an interview with CNN 2 weeks after the assault, she stated, "I was fortunate. I had credentials that should have protected me. I had a security officer advocating for me. I had multiple cameras recording. I had institutional knowledge of my rights, and I still got assaulted." Think about every black person who lacks those protections. Every person stopped by an officer who decides they don't belong somewhere. Every person whose presence is questioned, whose credentials are doubted, whose authority is denied based on appearance rather than evidence. This isn't about one bad officer. This is about a system that enables bad officers to act on bias without consequence. Do you think this exposes a bad apple or a rotten orchard?
The legal consequences for Officer John Reeves and the Miami-Dade Police Department unfolded on parallel tracks: criminal prosecution and civil lawsuit. The criminal case moved swiftly. The state attorney's office, recognizing obvious conflict of interest, referred prosecution to the Florida Attorney General. Reeves was charged with battery on a state official, felony; obstruction of justice, misdemeanor; official misconduct, misdemeanor. He pled guilty to all charges in exchange for probation and permanent prohibition from law enforcement. His statement to the court was brief. "I made terrible judgments. I let my ego override my training. I accept responsibility." He was 23 years old, 3 months into his career, and permanently barred from ever wearing a badge again. The civil lawsuit was more complex and more consequential. Lena filed in federal court under 42 U.S.C. 1983, alleging violation of her civil rights, and included state law claims for assault, battery, intentional infliction of emotional distress, and negligent training/supervision. Named defendants: Officer John Reeves, individual capacity; Sergeant Rinda Morrison, supervisory liability; Police Chief Robert Martinez, administrative failure; and Miami-Dade County, municipal liability under Monell. The damages sought: $10 million in compensatory and punitive damages. The evidence was overwhelming. 4 angles of video, witnesses corroborating every detail, medical documentation of injuries, expert testimony on bias, training records proving systemic negligence, complaint history showing pattern recognition failure. The county's attorneys evaluated the case and reached an unavoidable conclusion: this would not survive summary judgment. A jury would see the footage of a black state attorney being shoved for the ground for showing credentials, and they would deliver a verdict that would devastate the county's budget. Settlement negotiations began within 3 months. The county's initial offer, $2 million plus policy reforms, was rejected immediately. Lena's attorneys demanded full accountability: $10 million, comprehensive reforms, public acknowledgement of wrongdoing, and federal monitoring. The final settlement, announced 6 months after the assault: $10 million paid to Lena Porter for assault, civil rights violations, and emotional distress.
Hey, what are you doing out here? You don't live in this neighborhood.
I'm not bothering anyone. Keep moving.
Don't tell me what to do. You're loitering.
Officer, do not escalate. I'm working.
Working? Yeah, planning your next robbery.
Undercover FBI. You just blew a federal operation. This will cost your department a lot.
The body cam is shaking as the rookie officer rushes forward. No intro, no explanation, just pressure from the very first frame. A black woman stands alone on the sidewalk outside Willow Creek Estates. Calm, focused, but the tension you feel is instant. Then the officer snaps, "Hey, what are you doing out here? You don't live in this neighborhood." She doesn't flinch. "I'm working. Keep moving."
But what happens next, this single ignorant decision, did more than ruin a federal investigation. It triggered national outrage, tore through social media, and sparked one of the most expensive federal interference lawsuits the city has ever faced. $12 million. A shaky flash, her gold FBI credentials hitting the camera frame. Undercover FBI, you just blew a federal operation. Before we continue, where are you watching from? If this is your first time here, hit that subscribe button. Stories like these need to be shared. But what pushed this rookie officer to escalate so fast? And what did he never expect the Bodycam to capture?
Willow Creek Estates, Georgia, an affluent gated community 20 miles north of Atlanta. Manicured lawns, luxury vehicles in driveways, property values averaging $850,000. The kind of neighborhood where homeowners associations enforce paint color codes and security patrols check license plates of unfamiliar vehicles. It was 6:47 p.m. on a Tuesday in September. Golden hour sunlight filtered through oak trees lining pristine streets. Quiet, peaceful, exclusive. Special Agent Kendra Mitchell had been conducting surveillance for 3 weeks. She was 34 years old, 8 years with the FBI's Atlanta field office, assigned to the Violent Crime Task Force. Her current investigation involved a human trafficking ring operating across 3 states: procurement, transportation, exploitation. The kind of case that required months of patient observation, careful documentation, and absolute operational security. The target residence was 2847 Magnolia Drive, a 2-story colonial owned by Marcus Chen, a suspected facilitator who'd been linked to 6 missing persons cases. Mitchell's surveillance had confirmed patterns: vehicles arriving late evening, brief visits, occupants matching descriptions of trafficking victims. She was building evidence for a federal warrant, evidence that required visual confirmation of Chen's movements, license plate documentation, and timing patterns. That evening, she was positioned on Oakwood Lane, a perpendicular street offering sightlines to Chen's driveway. She wore business casual clothing, dark slacks, a plain blouse, comfortable shoes. Nothing tactical, nothing that screamed law enforcement. Her service weapon was concealed. Her FBI credentials were in her jacket pocket. Her surveillance notes were in a nondescript notebook that looked like any professional's daily planner. She was standing near a street sign, phone in hand, appearing to anyone who glanced her way like someone waiting for a ride or checking directions. Standard undercover protocol: blend in, maintain operational security, document without drawing attention. Officer Ryan Caldwell had been with the Willow Creek Police Department for exactly 4 months. At 23 years old, he was fresh from the academy, assigned to evening patrol, eager to prove himself. His training evaluations had noted concerns. Demonstrates tendency toward assumption-based decisions. Should improve assessment skills before solo assignment. But staffing shortages meant rookies were patrolling alone within weeks of graduation. That evening, Caldwell received a call from Willow Creek Security. Resident complaint: suspicious black female on Oakwood Lane. Doesn't belong to any household. Standing around for over 30 minutes. Residents are concerned.
Caldwell responded within 3 minutes. His body cam activated automatically as he exited his patrol car. The footage shows his approach: fast, aggressive, no tactical assessment. He saw a black woman in an affluent white neighborhood, and his training failed him completely. Instead of professional inquiry, he made immediate assumptions. The body cam audio picks up his first words, delivered with hostile authority. "Hey, what are you doing out here? You don't live in this neighborhood." Kendra's response was controlled, professional, designed to de-escalate without revealing her operation. "I'm working. Keep moving." But Officer Caldwell heard defiance where there was actually federal authority. He stepped closer, his voice rising. "Working? Doing what? This is a private community. You're trespassing." The body cam captured Kendra's face clearly. No panic, no guilt, just immediate recognition that this officer was about to compromise months of work. Her voice remained calm, but carried unmistakable warning. "Officer, you need to step back and return to your vehicle. I'm conducting business that doesn't concern you." Caldwell's face flushed. The body cam shows his expression shifting from suspicion to wounded ego. "Who do you think you're talking to? Show me ID now." Kendra glanced toward Shen's residence. A vehicle was in the driveway. Target vehicle she'd been documenting for weeks. Chen was visible through the front window. This was exactly the kind of moment she needed to observe, and this rookie cop was destroying it. "I don't have to show you anything. I'm not violating any law. Move along." What would you have done in her position? Let me know in the comments. Officer Caldwell's training had emphasized compliance. Commands must be followed. Authority must be respected. Resistance indicates guilt. But his training had failed to emphasize assessment, the critical skill of evaluating whether authority should be exercised in the first place. "You're loitering in a private community. That's trespassing. I'm ordering you to provide identification or you'll be detained." Kendra's jaw tightened. The body cam captured her frustration, barely contained beneath professional composure. "This is not a private community. This is a public street. I have every legal right to be here, and you have zero probable cause to demand identification." Caldwell reached for his radio. "Dispatch, I have a subject refusing lawful commands at Oakwood and Magnolia. Need backup." Before dispatch could respond, Kendra made a calculated decision. The surveillance was compromised anyway. Chen had likely noticed the patrol car. The operation was blown. So she reached slowly into her jacket pocket and pulled out her FBI credentials.
The body cam captured the moment clearly. Gold badge, FBI emblem, special agent credentials with her photo, name, and serial number. She held it at eye level, 2 feet from Caldwell's face. "FBI, Special Agent Kendra Mitchell, you are interfering with a federal investigation. Stand down immediately." The body cam shows Caldwell's face. Not recognition, not apology, skepticism and defensive anger. He squinted at the credentials, his voice dripping with disbelief. "Fake badge. You people buy these online all the time." Kendra's eyes widened slightly, the first break in her professional composure. The body cam audio picked up her response, measured but carrying steel beneath. "You people, officer, you need to verify these credentials through your dispatch right now. Call the FBI Atlanta field office. They will confirm my identity and active status." Caldwell waved dismissively. "I'm not calling anyone until you're properly identified. Turn around, hands behind your back." At Chen's residence, movement. The target vehicle backing out of the driveway, Chen leaving. 3 weeks of surveillance positioning about to be wasted because a rookie cop couldn't recognize federal credentials. Kendra's voice rose for the first time. "That vehicle is my surveillance target. You are actively destroying a federal operation." Caldwell grabbed her arm. "Stop yelling. You're under arrest for disorderly conduct." The body cam captured everything. Kendra's badge falling from her hand, Caldwell's fingers digging into her bicep, the target vehicle driving past them, Chen's face visible through the window, clearly noting the commotion. The entire operation compromised in real time. Kendra tried to pull her arm free, not to resist arrest, but instinctive reaction to unexpected physical contact. Caldwell interpreted it as resistance. "Stop resisting!" His voice cracked with panic and adrenaline. "I'm not resisting. I'm an FBI agent, and you just destroyed a human trafficking investigation. Have you ever seen an officer ignore ID like this? Drop your thoughts below." What happened next was captured from 2 angles. Caldwell's body cam provided close-up documentation of every constitutional violation. A resident across the street, drawn by the commotion, recorded cell phone video that captured the broader scene. Caldwell yanked Kendra's arm and spun her toward his patrol car.
The body cam shows her face striking the vehicle's hood, not violently, but with enough force that the impact was audible. Her FBI credentials lay on the ground where they'd fallen. Gold badge catching evening sunlight. Kendra's training emphasized de-escalation, even under assault. Her voice remained controlled despite obvious pain. You are interfering with a federal investigation. Stop now. Verify my credentials. Call your supervisor. This is your last chance to correct this mistake. Caldwell pulled handcuffs from his belt. Stop resisting arrest! The cell phone video shows clearly. Kendra wasn't resisting. Her hands were raised, her body language non-threatening, her movements deliberate and controlled. But Caldwell was operating on autopilot. Suspect refuses commands. Suspect challenges authority. Suspect gets arrested. The script he had learned in academy training, applied without any critical thinking. He grabbed her right wrist and wrenched it behind her back at an angle that made Kendra gasp in pain. The body cam captured her next words. I am Special Agent Kendra Mitchell, FBI badge number 47832. You are assaulting a federal officer. Every second of this is being recorded.
Caldwell's hands were shaking as he applied the handcuffs. Too tight. The body cam shows metal digging into her wrists. You have the right to remain silent. As he recited Miranda rights, Kendra kept her voice steady for the recording. I am asserting my right to contact FBI supervisors immediately. I am asserting my right to medical evaluation for the injury you just caused to my wrist. I am asserting my right to have these handcuffs removed, as I am a federal agent being unlawfully detained. Caldwell lifted her FBI credentials from the ground and examined them. For 3 seconds, doubt crossed his face. The badge looked authentic. The credentials were professionally printed. The photo matched the woman he'd just arrested, but admitting a mistake at this point meant admitting he'd assaulted a federal agent. So instead of correcting course, he doubled down. I'll verify these at the station. Get in the car. The cell phone video captured the moment a second patrol car arrived. Officer Sarah Martinez stepped out, a 12-year veteran who had been called as backup. She approached, assessed the scene, and immediately recognized catastrophic error. Her voice carried urgency and barely concealed panic. Caldwell, what are you doing? Subject was loitering, refused ID, resisted detention. Martinez walked to where the FBI credentials lay and picked them up. Her face went pale. These are real. She's FBI. Why didn't you verify before detaining her? She said they were fake. Did you call it in? Did you check with dispatch? Did you contact FBI Atlanta? Caldwell had no answer. Martinez turned to Kendra, her voice apologetic and professional. Ma'am, I'm removing the handcuffs immediately. This was a mistake. Not a mistake. Kendra's voice was cold, controlled, devastating. A mistake is writing down the wrong address. This was racial profiling that destroyed a federal investigation. I told him I was FBI. I showed credentials. He called them fake. He physically assaulted me. He compromised 3 weeks of surveillance targeting a human trafficking operation. This wasn't error. This was incompetence enabled by bias. The handcuffs came off. Kendra rubbed her wrists, red marks already forming. Martinez retrieved Kendra's phone and credentials, handing them over with visible regret. Another vehicle arrived, a black SUV with government plates. 2 FBI supervisors stepped out, faces grim. They'd been monitoring the operation remotely and responding to Kendra's emergency signal, a coded text she'd managed to send before Caldwell grabbed her. Special Agent Reed, Kendra's supervisor, approached Caldwell with controlled fury. His voice was measured, but carrying weight that made the rookie shrink. Officer, I'm Special Agent Reed, FBI Atlanta Field Office. You just interfered with an active federal investigation. You assaulted one of my agents. You destroyed operational security that took 3 months to establish. And you did it all while being recorded from multiple angles. Do you understand the severity of what just occurred? Caldwell's voice was barely audible.
I thought she was lying. You thought an FBI agent presenting federal credentials was lying. Reed pulled out his phone. I'm documenting this scene. Every detail, every witness, every violation. Your department will be receiving formal notification within the hour. Your chief will be contacted by my SAC, and you should contact a lawyer. Be honest. Was this racism or ego? I want your take in the comments.
Within 2 hours, the FBI's Atlanta field office had submitted a formal incident report to the Willow Creek Police Department, the Georgia Peace Officer Standards and Training Council, and the Department of Justice Civil Rights Division. The report was comprehensive and damning. Officer Ryan Caldwell initiated contact with Special Agent Kendra Mitchell without probable cause, based solely on her race and presence in an affluent neighborhood, despite clear identification as FBI, despite presentation of federal credentials, despite multiple warnings about federal operation interference. Officer Caldwell proceeded with unlawful detention and physical assault. The incident resulted in complete compromise of a 3-month human trafficking investigation, potential loss of prosecution opportunity, and civil rights violations documented on multiple video sources. By Wednesday morning, the Bodycam footage had been leaked to local news. By noon, it was national. By evening, it was international. The hashtag #LoiteringWhileBlack trended within 24 hours. Social media erupted with commentary, outrage, and countless stories from black professionals who'd experienced similar profiling. The comparison clips were devastating. Black doctors in scrubs questioned outside hospitals. Black professors stopped on their own university campuses. Black executives detained outside their own office buildings. CNN legal analyst Jeffrey Toobin provided commentary that captured the scope. This isn't just about one bad stop. This is about a rookie officer so conditioned to see black people as suspicious that he couldn't recognize federal credentials 2 feet from his face. And it's about a system that put him on solo patrol after 4 months despite training evaluations noting poor judgment. Thursday afternoon, FBI Director Christopher Wray made a rare public statement. The FBI takes interference with our investigations extremely seriously. When that interference is compounded by apparent racial bias and assault on one of our agents, it becomes a matter of both operational security and civil rights. We have full confidence in Special Agent Mitchell's professionalism and are supporting her completely. Officer Caldwell was placed on immediate administrative leave. His Bodycam footage was reviewed by Internal Affairs. His training records were subpoenaed. His academy evaluations were examined. And every single review reached the same conclusion. He should never have been cleared for solo patrol. The Willow Creek police chief held a press conference Friday morning. His statement was defensive and tone-deaf. Officer Caldwell was responding to a resident complaint about suspicious activity. He followed department protocols for investigating potential trespassing. While we regret the misunderstanding, the officer acted within his training. That statement lasted 6 hours before public backlash forced a retraction and apology. Because the body cam showed clearly Caldwell hadn't followed any protocol. He'd made assumptions, ignored evidence, rejected credentials, and escalated through ego rather than assessment. Should rookies even patrol alone? Let me know.
Monday morning, exactly 6 days after the incident, Special Agent Kendra Mitchell filed a federal civil rights lawsuit in the Northern District of Georgia. The complaint was 89 pages, meticulously documented, and sought $12 million in damages. Named defendants: Officer Ryan Caldwell, individual capacity; Police Chief Michael Warren, supervisory liability; Training Coordinator Lieutenant James Foster, inadequate training; and the City of Willow Creek, municipal liability. The legal claims were comprehensive: violation of Fourth Amendment rights, unlawful detention and seizure, violation of 14th Amendment rights, equal protection, racial discrimination, assault and battery, false arrest and imprisonment, interference with federal investigation under 18 U.S.C. Section 111, intentional infliction of emotional distress, negligent training and supervision, municipal liability under Monell for deliberate indifference, But it was the evidence section that made the case unbeatable. Bodycam footage showing the entire encounter, cell phone video from independent witness, FBI incident reports documenting operational damage, medical documentation of wrist injuries, expert testimony on racial profiling patterns, Caldwell's training records showing inadequate preparation, and most damaging, evidence of prior complaints about racial profiling in Willow Creek that the department had dismissed.
The city's attorneys reviewed the evidence and immediately recognized they had no defense. Caldwell's own body cam proved every element of the claims. The FBI's documentation was federal record. The witness video corroborated everything. And Caldwell's statement that the credentials were fake was recorded on his own equipment. Discovery revealed even more damaging information. Over the previous 2 years, Willow Creek PD had received 17 complaints about racial profiling in traffic stops and street encounters. 15 involved black citizens in affluent areas. All 17 were dismissed with notations like insufficient evidence or officer discretion appropriate. Internal emails showed supervisors were aware of this pattern. One email from Chief Warren to his command staff, "We're getting pressure from homeowners about maintaining property values and community appearance. Officers should be proactive about addressing individuals who don't appear to belong in residential areas." That email, coded language for racial profiling, became Exhibit A in proving municipal liability. Caldwell's deposition was scheduled in January. He appeared with his attorney, clearly coached, and provided answers that contradicted his own body cam footage at nearly every turn. Why did you approach Special Agent Mitchell? Resident complaint about suspicious activity. What specifically was suspicious? She was standing on a public street for an extended period. That's not illegal. What made it suspicious? She didn't appear to be a resident. How did you determine that? Silence. Officer Caldwell, was it because she was black in a predominantly white neighborhood? No, I don't see race. But you assumed she didn't belong based on appearance? I was responding to a complaint. The complaint said, black female who doesn't belong, correct? Yes. And you agreed with that assessment without any investigation? No answer. The deposition continued for 6 hours. Every answer either contradicted evidence or revealed racial bias. When asked why he'd called FBI credentials fake, he said they looked too official, like prop badges. When asked why he hadn't verified, he said, I intended to at the station. When asked why he'd physically grabbed her after she identified as FBI, he said she was becoming agitated. The body cam showed she'd been calm throughout. Settlement negotiations began in February. The city's initial offer was $2 million plus policy reforms. Kendra's attorneys rejected it immediately. Their counter demand remained $12 million plus comprehensive reforms, including federal monitoring. Do you think $12 million was enough? Yes or no?
The lawsuit had forced discovery of documents the Willow Creek Police Department had tried to bury. What emerged was a picture of systematic racial profiling enabled by policy, protected by supervisors, and celebrated by wealthy residents who wanted certain people kept out of their neighborhood. A 2019 memo from the Willow Creek Homeowners Association to Chief Warren. Our residents pay premium property taxes and expect premium security. We need assurance that individuals who don't reside here won't be permitted to loiter or conduct unauthorized business in our community. Translation: keep black people out unless they're working for white residents. A 2020 training document titled Community Policing in Affluent Areas included guidance that basically encouraged profiling. Officers should be attentive to individuals whose appearance or behavior suggests they may not be residents. Polite inquiry about their business in the community is appropriate. A 2021 email chain between patrol officers showed explicit racial bias. One officer wrote, "Another complaint about suspicious black guy near the tennis courts. Guess I'll go tell him to move along." Another responded, "That's the third one this week. These people don't get the hint." These documents, official police communications, proved the department had created a culture where racial profiling wasn't just tolerated, but expected. Expert witness Dr. Jennifer Martinez, a professor of criminal justice specializing in police bias, provided analysis. Officer Caldwell didn't act alone. He acted as a product of a system that trained him to see black presence in white spaces as inherently suspicious. His failure to recognize federal credentials, his immediate assumption of criminality, his escalation despite clear warnings, these weren't individual failures, these were predictable outcomes of inadequate training combined with institutional racism. The revelation that shocked even seasoned civil rights attorneys: Caldwell's academy training included only 2 hours on implicit bias. No practical scenarios, no assessment of racial assumptions, no training on recognizing professional credentials from other agencies, just a PowerPoint presentation that officers could sleep through, and academy records suggest many did. His field training officer evaluations noted Caldwell demonstrates good law enforcement instincts, proactive about addressing suspicious activity. But the same evaluations never defined what suspicious meant, or challenged whether Caldwell's instincts were based on actual threat assessment or racial assumptions. The Willow Creek PD had failed at every level: failed to provide adequate training, failed to supervise rookies properly, failed to address pattern complaints, failed to correct biased policies, and failed to hold anyone accountable until federal intervention forced their hand.